Our final speaker, and with any new legislation or changes, there's always legal requirements. So I'd like to introduce Alana Miller. Alana's with the law firm Baker & McKenzie from Sydney. Alana's a senior associate with Baker & McKenzie's Environment and Environmental Markets practice. She has a diverse range of experience in environmental law and environmental policy. Alana has acted for a wide range of private and public sector clients and advises on the legal aspects of international and domestic climate change policy, also carbon markets and emissions trading. In recent years, Alana has been involved in advising on regulatory and project structure issues and drafting documentation for a number of offset projects, including CDM projects, REDD projects, reforestation projects, savanna burning projects and soil carbon projects. Prior to joining Baker & McKenzie in May 2008, Alana worked for the Foundation for International Environmental Law and Development in London, where she assisted the Alliance of Small Island States in international climate change negotiations and provided advice to the European Commission on legal policy issues associated with emissions trading. So welcome, Alana.
Hey, good morning, everyone. My job this morning is to talk about some of the legal issues that arise from these new types of offset projects that are being developed under the Carbon Farming Initiative. And I guess as that brief introduction to my background explains, I've been working in carbon markets and doing various types of legal advisory and regulatory work around emissions trading schemes and the development of offset projects in both the international market and the domestic market. There are a couple of key questions that I think people should start thinking about when they are looking to potentially explore the options about developing a carbon offset project on their land. And one of the things that we haven't really spoken about in a huge amount of detail this morning, and I think Mick Keogh was probably going to cover this in his presentation, is just firstly the difference between an emissions avoidance project and a carbon sequestration project. So there are two broad categories of projects that might be developed under the Carbon Farming Initiative. A sequestration project is a project which is sequestering or storing carbon, either in the soil or in vegetation or trees. And an emissions avoidance or abatement project is a project where, through some type of management activity or use of some form of technology, you're avoiding emissions that would otherwise take place from a particular activity. So examples in the avoidance category is sort of things that would avoid methane from livestock, some of the those types of methane avoidance projects from intensive agriculture and also from landfill sites. So there are different requirements that apply from a legal perspective to emissions avoidance projects and carbon sequestration projects. And a lot of the slides I'll be running through today focus on the sequestration side because there are more legally onerous obligations with respect to carbon sequestration projects. And I guess the starting point, when thinking about these questions are firstly, where is the project taking place? Is it on land that you own or lease? And do you have the necessary entitlements to carry out the project on the land? Do you also have the carbon sequestration rights, so the rights to the carbon that is either stored in the trees or in the soil? There are questions around eligibility. Does the project meet the tests and the requirements that Michael mentioned in terms of being consistent with an approved methodology, being carried out in a manner that's additional? So what do you need to do to demonstrate additionality? Is the project on the positive list? Also, sort of some questions around what is the expertise that's needed to develop and manage the project. In many instances, there may be a range of different skills that are needed to develop a project. Some of those skills may be skills that you have in terms of already being actively involved in managing the landscape. Sometimes there are skills where you need to bring in third parties such as auditors or verifiers to assist. We've spoken briefly about methodologies, but again, they need to be front of mind in terms of what is the appropriate methodology for the project. And then importantly, these questions about long-term maintenance obligations and permanence particularly for sequestration projects. So I think they're some of the questions to think about as I'm running through some of the detail about this in this presentation. So firstly, starting with land tenure and carbon property rights. As you're all aware, there are a range of different types of land tenure that are out there. Most of us are very familiar with the concept of Torrens title freehold land, and many people are also sort of very comfortable with the idea of leases of that freehold land. But when you start looking at some of the other types of land tenures, particularly tenures which are managed under Crown ownership, where you have Crown leases, pastoral leases, perpetual pastoral leases, there are a number of questions about those types of land holdings in terms of whether or not you're actually able to legally develop a project on those lands, or if you are able to legally develop a project, what sorts of consents might you need from the Crown or from anyone else who has an interest in that. I think the real freehold land is generally fairly straightforward. If you own the land, then the starting point is that you have the entitlement to do whatever is permissible, subject to other regulatory development approvals and consents. Where you have a leasehold interest, then you need to think about is what I'm doing something that requires the consent of the landowner. And where the owner is the Crown in a Crown leasehold, do I need to go back to the Crown and get ministerial consent to carry out an activity? These issues aren't too much of a problem with the emissions abatement or avoidance projects, but they are very significant for carbon sequestration projects because of the long-term maintenance obligations. And that's where, in terms of leasehold interests, you need to consider things like how long is the lease. If you have the potential for a 100-year maintenance obligation to be placed on the land, but you only have another 5, 10, 15 years left of your lease, is that something that anyone else is going to consent to during the process? Pastoral leases are also interesting, particularly in the context of what are the permissible purposes that can be carried out under a pastoral lease, and is that permissible purpose consistent with a carbon farming initiative project? So, for example, one of the things that we've seen with projects that we've tried to develop in the Northern Territory in particular is that pastoral leases have to be the activities that are permissible are those pastoral purposes, whereas conservation, plantings, destocking, those types of activities are not necessarily consistent with a pastoral purpose. And so those types of things need to be considered when you're looking at the type of land tenure that you're proposing to carry out a project on. And I would note that sort of certainly in states that do have sort of strong regimes around pastoral leases, they're looking very closely at whether or not the Pastoral Lands Act should be amended to facilitate some of these carbon offset projects on pastoral leases as well. So land tenure, a very, very significant piece of the puzzle when developing a carbon farming initiative project. Understand the land that the project is being developed on, and whether or not there are any potential limitations or restrictions as a result of potentially leasehold interests or other Crown interests, or purposes for which the land can be used. In Queensland, that's been done through the Forestry Act, through the creation of what are known as natural resource products, and those natural resource products are effectively the trees and the vegetation and the carbon that's stored and sequestered through trees and vegetation. So in Queensland, someone who is a third party, not the landowner, can have what's known as the natural resource product through entering into a natural resource product agreement with the owner of the land. And that agreement is something that is able to be noted on the title to the land. It's treated in a similar way to as a profit or prondra right, or effectively a right to take the benefit of the product on the land, be it the trees, the timber, or ultimately the carbon stored in those trees and vegetation. But it's important to note that each state has slightly different legislative frameworks for carbon sequestration rights, carbon property rights. So in New South Wales you have a different scheme of rights under the New South Wales Conveyancing Act to the rights that are created in Queensland. And here they're profit pronder rights. In other states such as WA and Victoria, you have statutory proprietary rights created by law. And I think the important thing to note is that for the purposes of the Carbon Farming Initiative, you must be able to demonstrate that you hold that right. And that right can be held effectively in sort of a couple of different ways. As the starting point is, if you are the landholder, you automatically have all of those rights. So you can own the land, the trees and the carbon. You could also separate it out and just have one person owning the land and someone else owning the trees and the carbon, or the complete unbundling is where you have three different people each having different rights. But in order to pass on the right from the trees to the carbon, you'd need an agreement between all of those parties. So carbon sequestration rights are fundamental to your ability to carry out sequestration projects under the Carbon Farming Initiative legislation. You'll need to demonstrate to the government when you're applying for your project to be registered that you hold that right, either by being the landowner or by having a natural resource product agreement in Queensland that you can demonstrate that you hold that agreement and provide that with your application. So moving then on to the question of who's eligible to develop a project and what other types of interests may need to be consulted with. The person who develops an offset project under the Carbon Farming Initiative is known as the project proponent. And the project proponent is the person who has the legal right to develop the project, is responsible for carrying out the project, and in the context of carbon sequestration projects holds that carbon sequestration right. In order to develop a project, you need to be what's known as a recognised offset entity, and that includes demonstrating that you meet a fit and proper person test, which I'll come to. I mentioned before that the government's looking at Indigenous participation in the Carbon Farming Initiative, and where there are native title projects being developed, it would be the registered native title body that would be the project proponent for the purposes of a project developed on exclusive native title land. So looking at what you need to do to be a recognised offset entity, the fit and proper person test is a relatively sort of straightforward administrative test, really just sort of, and whilst we're waiting to see the actual details of what will be in the application forms, which is expected in the regulations, the bill sets out a number of types of characteristics that either a person or a body corporate must meet in order to be eligible. And essentially they relate to whether or not a person or a body corporate has ever been convicted of any offences that relate to matters to do with business administration, fraud, solvency, and in the context of